वेलकम टू शॉर्टकट्स चैनल। आज का ये वीडियो 120 की स्पीड से है। इसमें 1200 वर्ड हैं जो 10 मिनट में रिकॉर्ड किए गए हैं। अगर आपके वर्ड्स छूट रहे हैं तो किसी भी डिक्टेशन को ज़्यादा से ज़्यादा बार लिखने की ट्राई कीजिए। 3-4 बार लिखिए जिससे आपकी एफिशिएंसी इंक्रीज़ होगी। सो लेट्स स्टार्ट 3, 2, 1। The wife contested the petition admitting the marriage to have been solemnized on 13/11/1994 but denied the allegation of her having not lived in the matrimonial home. So also about the petitioner's father having come to fetch her. It was pleaded that as a matter of fact, after the petitioner came to fetch her, she lived in the matrimonial home till as late as 12/10/1996. Then, on 13/10/1996, the wife's brother Umesh Nandan came to fetch her for a couple of days, whereupon the husband and his father expressed anguish and physically misbehaved with them. Rather, at about 8 p.m., the wife was turned out of the matrimonial home, for which incident the first report was lodged in the police station Subhas Nagar by the wife's brother. Looking to their behavior, the wife got frightened and apprehending danger to life. She went to her father's sister at Azad Nagar and there she lived up to 1910-1996. Thereafter, she went to Chittorgarh with her father. It was pleaded that it is the husband who has declined to keep her in the matrimonial home rather on the death of husband's grandfather. She along with his father and he had gone to Vanera and her father wanted to leave her at matrimonial home but her in-laws declined to keep her. It was also pleaded that the husband's elder brother Yuvraj has written a letter to the father of wife on 29/1/1995 admitting the cruel treatment being meted to her in the in-laws' house. The learned trial court, on the pleadings of the parties, framed three issues. First being as to whether the wife is guilty of desertion without any justifiable cause for period of 2 years. Second being about cruelty being meted to wife by the husband, and third issue related to relief. During trial, the petitioner examined three witnesses, including himself, while the wife examined four witnesses, including herself. Both the parties tendered in evidence certain documents. Learned trial court, while deciding issue number one, catalogued the evidence of both the parties in about 5 pages, and then, after noticing the contentions of the respective parties in para 20, proceeded on the basis that since both the parties had laid evidence on the issue, the burden of proof becomes secondary and the issue is to be decided on the basis of the evidence. With this, it was considered that AW2 has though admitted that the wife had gone to police station on 13/10/1996 but has also deposed that she did not go from his house and that the theory of the wife having lived in the matrimonial home up to 13/10/1996 appears to be incorrect. Then it has been found that according to the wife's father, the wife in the first instance lived in the matrimonial home met for 15 days and then 2 months at her parental house and thereafter for 3 months at matrimonial home. This, if calculated, comes to 24/8 for 1996, while this story stands contradicted by the letters Exhibit 5 and Exhibit 7. which are of 10/8/1995 and 7/8/1995, written at the time when the wife was at her parental house. Thus, from these letters, it appears that from August 1995 the wife was not at her matrimonial home, therefore, it does not appear to be correct that she lived in the matrimonial home from December 1994 to 13/11/1996. It was also noticed that the wife's grandfather, Chandmal, has clearly deposed that the wife is living at Chittor for the last 8 years, and it was also noticed that the documents relating to police proceedings have not been produced, nor the document said to have been given to the wife have been produced. By making these observations, it has been concluded that the learned trial court feels that the wife is not living in the matrimonial home for the last more than 2 years since before filing of the divorce petition. Then in the next para, learned trial court has noticed the offers and counter offers given by the parties as conditions for living in the matrimonial home, and noticed that reconciliation between the parties could not be arrived at, which shows that the marriage between the parties has broken down, and it does not appear to be possible for the parties to live together. Then the learned judge has again reiterated that the wife has deserted the matrimonial home without any justifiable cause for the last more than 2 years. Deciding issue number two, it has been held that no evidence has been laid by the husband, and the issue was decided against the husband. In the result, the petition for dissolution of marriage has been accepted. Assailing the impugned judgment and decree, it is contended that the learned trial court has predominantly decreed the petition on the ground of breakdown of marriage, which under law is not a ground for dissolution of marriage, and for this purpose, learned counsel has relied upon the judgment of Honorable Supreme Court in Chetan Das versus Kamla Devi, reported in AIR 2001. SC 1709. In the alternative, it was contended that even otherwise, there is no evidence on record to show that the marriage was broken down. Various other contradictions in the evidence laid on behalf of the petitioner husband were pointed out, and it was contended that it is admitted position that the wife had gone to police station Subhas Nagar, Bhilwara on 13/10/1996, and there the husband's father had also gone, though there is a controversy on the aspect as to whether father of the husband was called by the police or he had gone of his own. But then this much is admitted that the father had gone to police station where the wife and wife's brother were there. According to the learned counsel, this $1 million circumstances shows that it is not established that the wife has deserted the matrimonial home for the requisite period of time, and therefore the ground of desertion for granting decree of dissolution of marriage is not made out. On the other hand, learned counsel for the respondent supported the impugned judgment and submitted that from the evidence produced by the petitioner, it is established that the wife had left the matrimonial home just after practically a fortnight, uh, and thereafter never returned, and all sincere efforts made on the side of the husband to rehabilitate the home failed. Thus, the ground of desertion is clearly made out, and decree for dissolution of marriage has rightly been passed. I have considered the submissions and have gone through the entire evidence, oral as well as documentary, and the pleadings of the parties.